Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Professor Patricia Kane. And Patricia, who I'm going to call Pat, is a professor of law at Santa Clara University. She's been teaching law for over 40 years. She started when she was 3.
Sure.
She briefly practiced law before she became a professor. Member of the Texas and Iowa bars and provides consulting services to law firms. Pat is a frequent speaker relating to tax planning for same-sex couples and has written many law review articles on that subject. The differences have reduced significantly. We're going to talk about that today. Anyway, but we are going to be talking about some of the tax concerns for same-sex couples, and because of some of the things becoming more similar now, because now we have a marriage across the country for these couples. We're also going to talk about unmarried couples.
Yes.
Related to this, today is September 2nd, 2015, and the reason why I mentioned the date is it seems like we have developments that are happening all the time, and particularly in this area, we've seen it really the big change this year. So as I get started, I'm going to caution our viewers, we're discussing areas in a complex area. This is a starting point for a bigger discussion with your own attorney, and we want you to get qualified legal and tax advice. And we're mostly addressing issues from federal and California standpoints because we live here in California, and California is a community property state, for example, and we have our own flavor of community property. Community property in other states works a little differently. So you really do need to get advice from your local advisors. Pat, thanks for joining me today.
Thank you for inviting me.
It's a pleasure having you again. So we've been following this issue for some time. June 26th this year, United States Supreme Court handed down a significant decision dealing with recognition of marriages as same-sex couples. And can you explain what the tax significance of this decision is and what it means and doesn't mean for California taxpayers?
Sure. Yes, that was the Obergefell decision, Obergefell versus Hodges, or Obergefell. I'm not ever quite clear how to pronounce it. I've heard it both ways. It was out of the Sixth Circuit, and it did hold that any state's refusal to recognize a same-sex marriage violated the 14th Amendment of the Constitution. But just to put this in context, let's go back 2 years. 2 years ago, also on June 26, just happenstance, the United States Supreme Court handed down another important decision, U.S. v. Windsor, which you and I discussed on this program at that time. Mm-hmm. U.S. v. Windsor ruled that the Federal Defense of Marriage Act, DOMA, which failed to recognize same-sex married couples for federal purposes, was unconstitutional. So that really was the turning point for California taxpayers who were in same-sex marriages, because at that moment in time, their marriages were recognized by the federal government. Because the IRS very clearly, and a couple of months after that, said that so long as you were married in a state that recognized your marriage, no matter where you lived, mm-hmm. you would be married for federal tax purposes. Mm-hmm. Now, of course, on the same day they handed down Windsor, they handed down the California case, the Perry case, that had been about whether or not the 14th Amendment protected the right of same-sex couples to get married. But the Supreme Court punted on that case. They ruled on a procedural matter. They said that the people who had appealed it up to the Supreme Court level did not have standing, and that instituted the district court opinions ruling, which had said Prop 8 in California is unconstitutional under the 14th Amendment. Mm-hmm. So, of course, anybody who got married before Prop 8 was already legally recognized by California. People who got married after Prop 8 would not be recognized, even if they were married by California, even if they were married legally in, say, Massachusetts. But that ruling by the Supreme Court also on June 26, 2013, instituted same-sex marriage in California. So Californians have not had many issues regarding this question of whether or not they would be recognized, except when they went to other states.
Right.
And of course, if they are taxpayers who had businesses in other states, or had to file a tax return, say, in Arizona,
right.
for Arizona income, they wouldn't be recognized in Arizona as a married couple. So Obergefell really took care of this. I mean, now, finally, same-sex marriages are recognized throughout the United States of America.
So for us, tax return prepares they've just eliminated a huge bunch of headaches.
Yes, yes. We think so. We don't know. There's some things we don't know about. There's this question of retroactivity. When Windsor was handed down, the effect of a Supreme Court ruling, or any court ruling actually, that a statute is unconstitutional, the way to treat that statute is as though it never existed. So if the federal DOMA never existed, then anybody who got married, say in 2004, should have been recognized by the federal government from 2004 going forward.
Right.
So the IRS did make clear that they would allow Windsor, that they would treat Windsor with retroactive effect.
Right.
And so long as the statute of limitations was still open, taxpayers could file amended returns. And the IRS was very generous. They said, if it benefits you, go ahead, elect to file an amended return. But if it harms you, you don't have to file an amended return. Nobody has to actually file an amended return anyway. It's optional. And so they were very, very clear about what the retroactive nature was of Windsor. Now that we have obergefell, which is telling states that didn't want to recognize marriages that they must recognize the marriage, but we still have a clerk in the state of Kentucky who won't issue marriage licenses because it violates her religious beliefs, even though the Supreme Court has pretty much ruled that that's what she needs to do. So it's good you mentioned the date, because that status may change by this Friday. But now that we have that, we don't know from each state that, again, it's not going to affect California taxpayers unless they have income tax returns filed in these other states. We don't know whether those other states will let you file retroactively or amended. We'll find some say yes, some say no. Most of them say, well, we're looking at it. We'll let you know.
Thanks.
Yeah, right. Just what we needed. Yeah.
Okay, so
I would say minimal impact for California.
For California. So I think you covered this point here about Arizona in what you just mentioned. So.
Yeah, I mean, there's one other issue, I guess. It could be related, financially at least. I mean, if a California married couple owned real estate in Arizona.
Yes.
Yeah. Now the rule is it's community property if the domicile recognizes your marriage, but the property's in Arizona, so Arizona would have to recognize the marriage, which it didn't for years. Now it does recognize the marriage because of obergefell. So that couple that has owned that real estate in Arizona may suddenly discover that it's actually community property, even though they didn't know it at the time or didn't think it was, because Arizona didn't recognize the marriage.
Right. So part of what is involved in all of this is that, again, particularly these couples, the same-sex couples, really need to get together with their tax advisors, their attorneys, and so forth. And maybe I should say former married couples, too, because we've got basis adjustments, we've got all sorts of things that are hinging on all of this, when you have an inherited property and so forth, and not to mention, their estate planning documents and so forth.
Right. It is getting less confusing for everyone, but we aren't out of the woods yet.
At least we're starting to have an idea of what we need to do. It just means, there's a lot of work ahead for
sure, and I'm not sure we know. I'm not sure all of us have realized what some of the issues might be. There may be some
maybe
surprises
not yet.
ahead.
Okay. So what is some unanswered questions you think that there might be as part of the fallout from this decision,
Well, this decision is about marriage, right? So I need to remind everybody that in California we have this alternative status that we call marriage equivalent or registered domestic partnerships.
Right.
And the IRS has very clearly said that we will not treat registered domestic partners as spouses. Well, they don't have any rules at the federal level about tax rules for registered domestic partners, so the IRS is treating them like strangers, which is very strange in my view, because they're not strangers, they're like spouses. I've argued to the IRS that they should be treated as spouses, but they say, no, if California wants to treat them as something other than spouses, we're going to honor that and treat them as something other than spouses. I thought, well, but in California, they file a joint tax return because California does treat them as spouses, and yet the IRS is forcing them to file as single taxpayers at the federal level. So we still have that problem.
All right. Now, there's also a side issue related to this, right? Wasn't part of the reason for putting secondary, maybe way down the list, but there are some actually opposite sex couples.
In California,
In
only if one
California.
of them is 62.
Yeah, and so they have taken this status basically to protect Social Security benefits, as I recall.
Right. Since a registered domestic partnership is not a marriage, and the rule is if you're drawing on your surviving spouse and you're taking survivor spousal benefits from your first marriage, when you remarry, you will lose those benefits. And so if you simply enter into a registered domestic partnership, you won't lose those Social Security benefits. Now, some people are confused about this because there's other rule under Social Security about whether or not you're entitled to spousal benefits in the first place. And the way that statute is written, it says, yes, you're entitled to spousal benefits so long as your marriage to this person is recognized in your state of domicile. Or alternatively, if the state doesn't recognize your marriage, we will give you benefits if you would receive a spousal inheritance share from this person. And that literally covers registered domestic partners
Yes.
and civil union partners because they get the same intestacy share that a spouse does. So they're covered by Social Security, can claim survivor benefits, but if they enter into another registered domestic partnership, they don't have to lose prior spousal benefits.
Yeah. Well, I mean, I guess what I'm getting at is it sounds like, that we want to have our cake and eat it too, and I don't know if that's going to work out. And
so far the IRS is letting it work out, which
Yeah.
is, that's the other thing. It's like the state can manipulate. You can avoid the marriage tax penalty. Why don't all couples that have equal income and pay more income tax married rather than single, why don't they all get divorced and enter into a registered domestic partnership and report that way? Then they pay fewer taxes, lower taxes at the federal level.
Well,
You haven't considered it, I assume.
Well, no, I'm just saying that, I mean, it's kind of a confusing issue because there's all these conflicting rights and so forth and statuses between the two. But the big thing is the Social Security for these particular people. That again, that they're the opposite sex couples that have this sort of a relationship.
And they avoid the marriage tax penalties at the federal level.
Okay. Okay. So, do you have other advice for same-sex couples in California or the return of repairs?
Let's talk a little bit about unmarried couples, because
Okay.
that's where the interesting question is.
Because and that's sort of where we're around with this registered domestic partner issue.
Registered domestic partners
because they're
are
considered
not
to be
married,
unmarried
right.
for
And then, of course, there are
federal
also just
tax.
cohabitating couples who are not married or registered, and they're simply unmarried cohabiting couples.
Yeah.
So we had this rather interesting decision that came down just a little bit ago in August from the Ninth Circuit Court of Appeals. This deals with the limitation on the mortgage interest deduction.
Okay.
Now, this is going to sound a little bit
Oh,
dry
yeah.
at first.
All right,
But,
yeah.
the
Go ahead.
mortgage interest deduction is
This was
important.
an interesting decision. Yeah.
The mortgage interest deduction is very important to a lot of people in this country, especially in California where the price of housing is quite high.
Right.
So, before I moved out here, I actually calculated what size house or what price house I could afford by factoring in my mortgage interest deduction.
Mm-hmm.
And you can only claim the mortgage interest deduction if you have first a qualified residence and then if you have qualified debt. Qualified debt is something that is secured by the residence, and it has certain limitations. So it's a qualified debt if it's acquisition indebtedness, that is debt used to acquire the residence, but that debt can't exceed $1 million.
Right.
It's qualified debt if it's home equity debt secured by the home, but that debt can't exceed $100,000.
Right.
So the total qualified debt is basically $1.1 million.
Right.
The code, however, is not very clear about how to apply that limitation. Now, I think it applies per taxpayer. It doesn't explicitly say $1 million per taxpayer or $100,000 per taxpayer. But taxpayers are the ones that have the debt. Mm-hmm. We determine whether it's business debt, investment debt, or home mortgage debt, depending on how the taxpayer uses the funds that he or she borrows. So I had always assumed that this was a limitation per taxpayer. And the difference, and because of some other language in the statute, husbands and wives are treated as one taxpayer.
Right.
So this is another instance of a marriage penalty, marriage tax penalty.
Right.
If you're two single individuals owning a home together, and you have mortgage liability equally divided between you, you could deduct interest on the first 2.2 million, 2 times the limitation amount, because you're 2 taxpayers. If you marry, however, you're going to suddenly have your interest reduced to the interest paid on 1.1 million.
Right.
And then lo and behold, in 2009, the IRS issued a CCA. It was based on an audit in Southern California, I know because I talked to the accountant involved, and CCA being a Chief Counsel Advisory.
Right.
It has no binding effect, it's not really authority, but it lets you know what the IRS thinks the law is. And they said that the limitation was applied per residence.
Right.
And I thought that was absolutely wrong. I advised people that it was wrong. And then lo and behold, in 2012, the tax court agreed with the IRS in a case involving 2 unmarried men who owned a house together and whose debt exceeded 2.2 million. And each had deducted his share of the interest on what he thought was his 1.1 million of debt. Tax court, Judge Cohen writing the opinion said, no, we agree with the IRS. So the case got appealed to the Ninth Circuit, and I got involved because I've been writing on this for years, and I managed to put together an amicus brief on behalf of tax professors around the country who thought the law was quite clearly applied per taxpayer. Mm-hmm. It was before the Ninth Circuit for over 2 years, and then finally, August 2015, just last month, the Ninth Circuit ruled. They ruled in favor of the taxpayer. They reversed the tax court. And so now, all those people whose accountants told them that they could not deduct interest on $2.2 million of debt are considering amending their returns and claiming the interest on the full amount per taxpayer, $2.2 million. Mm-hmm. So that was kind of a fun win in the Ninth Circuit. Right. Now, it may be too recent to know how this is going to fall out. The IRS may say it doesn't agree with it. I mean, I guess they could even ask for a rehearing. But I think it's a narrow enough issue because we've gotten rid of the federal DOMA. Married same-sex couples are limited to 1.1 million, so this only affects cohabiting couples or cohabiting families. You know, in San Francisco, because the housing is so expensive, we have these tenancy in common purchases called TICs. So you might have 2 or 3 families who come in together and buy a home, and they may have over 1.1 million on that one home. So it affects them as well.
Right. So I was looking at some statistics earlier today because we were going to talk about this thing with the unmarried couples. And so one of the statistics, this is from U.S. Census Bureau. They said that it's a report called America's Families and Living Arrangements in 2000. The number of cohabiting unmarried partners increased tenfold from 1960 to 2000.
And it's increased even more up till 2010. In fact, the household that is in the minority is the married couple. Yeah.
Says the number of cohabiting unmarried partners increased by 88% between 1990 and 2007. And one of the things, of course, they said is the way our culture is working is even the people who are getting married, they're living together first.
Yes.
Very often. That's the way that it works. In 2011, the Census Bureau reported 7.6 million opposite-sex cohabiting couples in the country, with a separate report listing the number of cohabiting same-sex couples at about 514,000 as of the 2010 census. So anyway,
it's a growing demographic.
Well, what's happening, is that marriage. Well, one thing my understanding is that marriage has sort of become an affluent status, that not as many.
Yeah, if you look at the statistics of who's married, it will be people with higher educational levels, higher income. It's just, and yet the federal government seems to think that if everyone just got married, it would help them in their poverty situation. I think wealth transfers would help them more than marriage. Yeah,
and of course, and so there's all sorts of issues. Now, one of the things, of course, in a sense that has sort of reduced the pressure on this is increasing the exemption, the state and gift exemption. And gift tax exemption. Yeah, yes. It's up to about 5,460,000 or so now, I guess.
5,430,000.
430. Yeah. Okay. So anyway, with it being so high, it reduces the pressure, particularly for these lower income people. But there are other side issues.
Well, for the very low income people, they may experience marriage tax penalties. Because if you think about it, I mean, they've reduced all the rates at the low level. So the rate structure won't create a marriage tax penalty for low income people. But if one of them is getting the EITC, the earned income tax credit, based on his or her income, and then they marry, the determination is made on the aggregate income of the couple. So they might be better off not marrying in order to protect their EITC.
See, and this is why I say that there's so many conflicts, because, for example, again, the inheritance rules, particularly for intestacy, and again, poor people don't tend to have wills.
Right.
And so when you're living with somebody, that person doesn't really have any inheritance rights, whereas a spouse would automatically,
Right.
Particularly if it was community property.
Well, even rich people sometimes don't make wills. There was this astounding story in the paper about a week ago of a lesbian couple from many years ago, very wealthy. I mean, we're talking about estate taxes in this case.
Yes.
And one adopted the other. The older one adopted the younger one, and the younger one inherited. But now the younger one has died, and she didn't make a will. She figured that her brother, her blood-related brother, would be her heir. And he's the only family she had. But it turns out, because of the adoption, because her lover adopted her, it cut off her inheritance ties with her natural family.
Isn't that fascinating?
See, so much going on here.
Yeah. So anyway, so that's part of the reason I wanted to have this conversation with you about this, because there's a lot of things to think about. Like you said, I mean, income tax-wise, it may make a lot of sense, for people to have some other status, maybe even registered domestic partners if they qualify. But a younger couple, they couldn't qualify if they were opposite-sex couple.
In California. Although I happen to think that's discrimination. If a same-sex couple at any age can enter into a registered domestic partnership, it should be opened up to opposite-sex couples of any age. And there are other states like Nevada and Illinois where it is open to all opposite-sex couples.
Time will tell.
Yeah. Yep.
Okay. See here. Let's see what else.
Well, I want to make one point, because you just said there are a lot of things for people to think about around marriage. I mean, taxes should not drive the decision to marry. There are a lot of other considerations. But I think people who are thinking of getting married ought to think in advance how their tax situation is going to change. As I tell some of my students, if you're planning for a wedding in the fall and it turns out you're going to pay $10,000 more in taxes this year because of that, because if you get married in the fall and are married by December 31st, you're married for filing a joint tax return. Maybe you want to postpone that wedding until January.
Yeah, I gave exactly that advice years ago. I had an older couple that came to me. That was one of the more interesting things that ever happened in my career. So this couple that I knew, the husband was his mother that was getting married. She had been a widow, and so they were all concerned about whether she was being taken advantage of or whatever. And really their status was pretty similar. And so I said, okay, you can get married. But I said, if you wait until January, then you'll save enough tax for a really nice honeymoon.
Right.
And they were too hot and heavy. They wouldn't wait.
Well, that's it. Taxes don't always drive the decision to marry.
Everything. But one of the things that I want people to think about, particularly unmarried couples, is you can cover a lot of these things by doing things like having a will or
having
trust.
a premarital agreement.
But
you can't change the tax rules.
Well, you can't change the tax rules, but there are other things to think about, and so people think, oh, because we're unmarried, this is a simple relationship. This is nothing to be concerned about. And yet when they're, pouring their funds into the household, if it's unequal, there are gifts that may be involved.
Right.
There are a lot of technicalities. And again, some of this has been diffused a little bit, but supposedly we're supposed to keep track of this stuff.
Right. So have you ever filed a tax return for a gift tax return for someone who was supporting someone that they weren't legally obligated to support? That's the technical rule from the IRS.
Yeah. So I did do one that I had an older gentleman who had a girlfriend. He was married. And
that's not good for other reasons.
So he wanted basically me to sign, to prepare a gift tax return for him because he was giving money to his girlfriend. And by the way, don't tell my wife.
Yeah.
So, oh boy, that's pretty awful. Okay, well, we probably have about a minute or so left. Maybe you can throw out a final thought here.
Well, just one more point I failed to make about registered domestic partners. The real problem for them is when they dissolve their relationship. When they dissolve their relationship, because they're not treated as spouses, they're not entitled to use any of the divorce tax rules, the statutes in the Internal Revenue Code. So some people have suggested that this couple get married and then get divorced solely so that they can use these rules. And several practitioners have raised the question, if you marry solely for the purpose of getting a divorce, is that a sham transaction?
Yeah, I think it is.
And if the IRS ever found out about it, might they deny you marital status and therefore deny you those rules?
Yeah, that's tough. So folks, just to highlight this to you in just a moment, basically a married couple can divide their property without there being a gift or anything like that.
Well, and of course under common law, they can, if they're splitting community property, if they're registered domestic partners and splitting community property, that's a non-taxable event as well. It's when separate property gets transferred.
Okay. Folks, we're all out of time. Thanks for joining us. We'll see you next time on Financial Insider Weekly.